ride on this one, but I'm looking forward to it. I'd like to get straight into the discussion. Before I do, I'm going to put here a link to everyone's bio, but just very briefly, in lovely alphabetical order, we have Jeffrey Starks, the Commissioner for the Federal Communications Commission, Phil Weiser, who's the Attorney General of Colorado and founder of Silicon Flatirons. And we have Christine Wilson, a Commissioner on the Federal Trade Commission. So the FCC and the FTC in one room. This is going to be very exciting. I'm going to put this link here in a minute, but just as a personal note, I must say we had several conversations with panelists beforehand, and I think this is a very exciting topic. This, it's always fun to look at the road ahead. That's essentially what day 3 is all about. We're going to cover a lot of ground here, but still, of course, focus it on the tech policy area. I think it should be a very good discussion. To that end, we certainly really encourage you to ask questions. I believe we have some help from CU folks to make that going. I think you can either you can put a question into the chat and we can answer it. We certainly welcome questions from students to make this really a lively topic here. So I'd like to just go ahead and get right into it. I'd like to start with General Weiser, just, and certainly your role in the antitrust landscape, to say the least, lately. And I just want to get right into it in sort of the vein of consumer protection, is what you see the role of antitrust law in establishing this, or establishing to begin with, this trust between big tech and the public.
Thanks, Jack. I have to note, you're virtually in Boulder, so you should be taking off that tie. Apparently, Commissioner Starks got the memo, and
it's a little tight. So. It's a little tight.
Yeah, we loosen up out here. It's Colorado. So yeah, thank you all for being here. Thanks, Jack. What a great panel. 2 wonderful commissioners. It's an honor to be here. Thank you, Amy, for your leadership, keeping this tradition. These conversations, as the video before highlighted, are really important to be thinking about. And the topic that Amy and the team put the finger on this year is central, and it brings together a lot of themes, antitrust being one of them. It's ironic, just for a history lesson, antitrust is not about trust in the sense we're talking about it today. It's about trusts, which were a legal form of aggregating companies. So they talked about the sugar trusts back in the day. So that's how we get the word antitrust. And antitrust enforcement conducted properly can promote trust in markets. Consumer protection can promote trust in markets. Tim Muris has a great speech he gave several years ago at an Aspen conference where he talked about both antitrust and consumer protection as levers in service of markets that treat people properly. Part of the lack of trust right now in the tech sector is people don't believe they're being treated fairly. People believe they're being taken advantage of. They don't have choices. People are concerned that the levels of concentration in our economy have led them to be squeezed unfairly. Even workers have seen sorts of practices like no poach agreements, even in things like retail fast food restaurants, where they're not able to go from one chain to another. And that, again, is all undermining trust that the market is working. So antitrust law and antitrust enforcement, I believe, consumer protection law, consumer protection enforcement are mechanisms to build trust that we can have a free market system that works for everybody. What's happened recently has been more concentration. Big tech is a notable example where we're seeing it, but I also have to say lots of other industries are worth noting. Airlines, for example, we've seen more concentration, and there was a time frame a few years ago when oil prices went down, which would have been a big input for airline travel, but prices for travel didn't go down. Literally, the companies just gave free peanuts and made record profits. That doesn't happen in competitive industries. So we need to have the sort of enforcement and the leadership we have here with my colleagues and I to be able to build trust and to be able to address both undue consolidation on the merger front and on the back end front, monopolization abuses as well.
I think your comment about free peanuts makes me realize how much I want to get on an airplane again, but time will tell on that. I just wanted to drill in a little bit about this, and it's sort of interesting that trust is morphed into a different thing compared to obviously where the phrase antitrust or the term antitrust came from. But I mean, you particularly, I'm curious your thoughts on, just to be blunt about it, how companies like Google and Facebook have essentially, in your view, abused their dominant positions in the marketplace.
I would recommend reading the Facebook complaint and the Google complaint. It's not easy reading. They're both probably around 100 pages. They detail the concerns. Let me start with Facebook, then I'll do Google for a minute. So Facebook, there was a time period when they were facing competitive threats. And during that time, our complaint explains, they were more attentive and concerned about protecting users' data, protecting privacy. When companies face competition in the marketplace, they can't take consumers for granted. They have to provide better products and services. Our concern is that Facebook has been able to establish a marketplace dominance and then protect it through what we describe as either buy off would-be rivals or bury them. And that is a dynamic that is antithetical to free and fair competition and to consumer choice. In the case of Google, they took a stronghold position in mobile with a number of exclusionary contracts. They contract with Apple, for example, making sure that they had the ability to distribute their search product and others didn't. What's happening right now is, as we look to new frontiers, think connected cars, for example, we're seeing the same story play out. And my goal is to allow competition on the merits, so that if you're an incumbent monopolist, you have to compete along with others, and you don't get to put a thumb on the scale undermining would-be rivals through predatory tactics. And those are the concerns we have. We want to see competition on the merits. We want to see consumer choice. And whatever incumbent monopolists cross that line, we're going to work hard to keep them in line and to provide consumers with choice.
And Commissioner Wilson, I mean, speaking of Facebook, I wonder if you could maybe talk a little bit about that perspective from Facebook, especially, I mean, I'm sure everybody knows, but if you didn't, that the commission had essentially sued Facebook a couple of months ago, feels like 4 years ago, which was December of 2020. I just want if you could maybe expand upon that, or just get your thoughts on Facebook and its position in the marketplace.
Sure. So unfortunately, I can't talk about any specific company or any ongoing litigation, but I would like to circle back to General Weiser's opening focus on competition. And I agree, we all have this innate sense of fair play, right? Even children are quick to label actions fair or unfair. Just try giving one of your children a pie wedge that's, half an inch wider than you give to your second child and see what happens. And consumers want competition on the merits. To use a sports example, given how recently it occurred, we all love the Super Bowl, but we really don't like Deflategate. Or in antitrust terms, we like it when companies compete aggressively for our business. We like it when they deliver new products and low prices, but we all instinctively recognize that agreements to fix prices in smoky back rooms are undesirable. And we'd be dissatisfied if one competitor burned down the factory of another to get ahead. And that's an extreme example, but antitrust enforcers ensure that companies are playing by the rules of the road and providing competition on the merits. Now, to hark back to General Weiser's references to Tim Muris, who was chairman of the FTC 2001 to 2004, and one of my mentors. I served as his chief of staff when he was chairman. He always noted it's important to underscore that enforcers and regulators are referees, not star players. We shouldn't be in charge of picking winners and losers. We should let consumers choose which products and services they want to patronize and let them vote with their feet. And I think there's a fine line between policing the market, ensuring that the rules of the road are followed, and then skewing over into actually picking the winners and losers. And some of the proposals that we've seen for regulating or for enforcing the antitrust laws actually have moved into picking winners and losers, and that's when I become concerned, because I believe that free markets deliver the best outcomes for consumers.
Commissioner Starks, I think I saw you nodding. I don't know if you were nodding or if it was you were adjusting the webcam, but I wanted to maybe see if you had any thoughts on this too before I had a question for Commissioner Wilson.
Oh, nodding in the sense, of course, that I'm honored to be on a panel with such august folks, including the commissioner and, of course, the attorney general there in Colorado. And I was just adjusting my screen. But to be sure, also in the kind of telecom space that I regulate, amongst my fellow commissioners as well, was nodding probably in the sense of when we are laying out a lot of our rules, one of the principles that I abide by is trying to not have play a tech neutral way in the way that we think through our rules, and making sure that I'm not favoring cable providers as opposed to satellite broadband, and making sure that there is a frothy, robust marketplace, even amongst competition for a lot of the telecom services that we all have and certainly want to have and see more ubiquitously.
If I can go back to Commissioner Wilson, I remember one of our early conversations, I was very struck because I liked your turn of phrase, and I want you to correct me if I'm wrong here, of course. You had talked about when we look at this maybe just general, like this failure of antitrust enforcement or the system we're in, is it really more of a question of unchecked crony capitalism and beltway lobbying? Is that the people who are supposed to be watched are the ones writing the rules for themselves? And I just wonder if you, in terms of the way forward here, you talked about picking winners and losers, and I'm just curious how we can make this fair, especially in this paradigm that you had suggested.
Yeah, absolutely. So through various international forums like the OECD or the International Competition Network, countries around the world have worked for a couple of decades to converge on best practices for antitrust enforcement. How can we do it in a sound and economically focused way that produces the best outcomes for consumers? And that is the goal of antitrust enforcement in this modern age. It's to maximize consumer welfare. And what I've seen since becoming a commissioner in the last 2.5 years is an uptick in dissatisfaction among regulators and enforcers from around the world, sort of channeling dissatisfaction of their constituents in this notion that somehow competition has failed us, capitalism has failed us. And I've had a lot of conversations with people from around the world about this issue. And through those conversations, I came to conclude that it's actually not capitalism that's failed us. It's crony capitalism that's failed us. Legislatures in crony capitalism create laws and regulators create rules that do pick winners and losers. And it makes citizens feel hopeless because they see no way to better their lives if they aren't favored by the rule makers. And so to restore their trust, I believe we need actual capitalism, a system in which the production of goods and services is based on supply and demand in the market rather than central planning, and government intervenes only where necessary to address market failures. And we see a lot of this activity, not just in DC before Congress, but across the country. It happens in Denver, it happens in Sacramento, it happens in Austin. Every time an incumbent in the market asks to make it a little harder for someone else to enter the market, that's lobbying that hurts competition. And the pandemic has given us a great example of the constraints, the straitjacket that these laws and regulations impose on the market. So we've seen certificates of need regimes where a hospital has to petition for permission to get a new piece of machinery or enter a new line of business or add beds. And in that process, its competitors and rivals have the opportunity to come in and protest and say, if that hospital expands its capacity, it's going to keep me from making as much money. And sometimes certificates of need are refused and hospitals cannot expand. And we saw this during the pandemic. We saw other kinds of constraints that arise from this crony capitalism. Nurses aren't allowed to practice to the full scope of their training and abilities because doctors have lobbied to limit what they can do. Or they're not allowed to practice across state lines because there's legislation that inhibits them from doing that. And so we saw in state after state and also at the federal level, a lot of these laws and rules and regulations suspended or repealed because people began to realize when push comes to shove, those restrictions are limiting competition, limiting the ability of companies to respond rapidly to changing needs, to the crisis of the pandemic. And I think that's one example, but But there are so many examples throughout our economy. And I think if we lifted all of the rules and regulations that incumbents have lobbied for, not for the benefit of consumers, but for the protection of their own profits, we would see a much more vibrant economy, much more innovation and investment and competition that would benefit consumers instead of incumbents.
Jack, if you're on mute, but I could jump in here if that's okay.
I was literally just going to say, sans that technical faux pas, if anyone else wanted to jump in. So go right ahead.
What I would say, and I think Commissioner Wilson touches on a theme here that does have global significance at a time of increasing distrust in institutions generally. The concept of the rule of law is that we have legal rules that themselves are fair, are applied fairly and transparently. That is a gold standard that at our best, antitrust enforcement, consumer protection enforcement learns from. At our worst, as Commissioner Wilson just said, we're engaged in picking favorites, ourselves putting a thumb on the scale. And that requires intellectual and regulatory humility. Just like Commissioner Stark said, that if you support a policy goal, say, for example, universal service, don't favor one technology over the other, favor the outcome you want, and allow competition to get there. And what, again, Commissioner Wilson put her finger on, and we've talked to a lot of Silicon Flatirons conferences in the past, is tomorrow's innovator doesn't have a lobbyist, but today's incumbent does. And so part of the challenge for all of us in policy-making positions is, how do we hear from innovators? How do we hear from affected groups who may not be able to advocate for themselves because they're less well off, they're being taken advantage of, or just a broad swath of consumers who don't necessarily organize themselves? And that injunction to all of us is something that's really important, both in terms of how the institutions work and how we within the institutions operate.
And we're going to have some questions later, so a bit of housekeeping. If you want, I see somebody has already put a question in there. If you click the Q&A and type a question, we'll queue those up. I really appreciate it. That being said, I'd like to just, because this is relevant to the topic now, and Commissioner Wilson, somebody had asked, what you were discussing, but isn't that essentially conduct protected by the First Amendment in North Pennington, the framework? I'm just curious your thoughts.
Sure, absolutely. That I am not saying that the lobbying is an antitrust violation, and all of us under the First Amendment have the right to petition legislatures and politicians and judges for outcomes that we would like to see. But what I'm saying is that when assessing whether to pass a law or to pass a regulation, it would be really great if policymakers would consider not just the impact on incumbents in the market, but also the impact on consumers. And we recognize that when we partner with state attorneys general and states that are considering new laws or regulations, obviously states have the ability to protect and promote the health and safety and security of their own citizens, and obviously they can pass the laws that they want to pass. But through our competition advocacy role, we like to participate when we're requested to participate in order to help identify the impact that those laws and regulations will have on consumers, so that policymakers can weigh all of those competing needs and put the consumer's interest into that calculus.
One thing that came to my mind, and eager to kind of get Commissioner Wilson and maybe the Attorney General's thinking on, if they so choose, but something that was kind of nibbled about, but it is definitely in competition. One of the things that the FCC has that is unique in some ways is the responsibility, as we are assessing mergers, of specifically promoting the public interest, is what our statute says. And we have a unique situation where we expect applicants who propose a merger to us to demonstrate that their proposed transaction will not only protect competition, but actually enhance competition. They have the burden before the FCC to show that they are going to enhance competition. And one of the things that we've seen play out, and I know it's played out in the telecom space, and I know it's reverberated in other places as well, are some of the merger conditions that come along with mergers that are consummated. And ultimately some of the questions that have been bandied about somewhat theoretically on how to unwind a merger that has previously been consummated that we're no longer happy with. And so this does also get into the concept of public trust on mergers. We certainly know before the FCC that we have had merger condition. Obviously, there are those structural conditions where somebody has to divest or sell off part of a business in order for the deal to move forward. But some of those other merger conditions that are promised to us as regulators that then down the line we expect to be held and hold folks accountable, but sometimes when those merger conditions are broken, trying to figure out how and how to deal with that, and whether there's a monetary penalty or like you said, in some sense, the very hard task of trying to unscramble the eggs, as it were. But I kind of throw that out there as something that I know is a competitive force. It is also, I think, deeply related to the public trust that we're talking about, where enforcers and regulators and attorneys general will hold folks accountable and enforce what has been regulated on our watch.
Commissioner Starks, the one thing that I think this brings up, and if you look at kind of sort of bread and butter issues to the degree that these are even talked about at the dinner table of most normal households, I know they are mine, is essentially the vacuuming up and monetizing of our data on social media platforms or on big tech platforms. And it's pretty clear that consumers have become increasingly concerned about this practice. We've talked now about what policymakers should be doing, lawmakers, really policymakers. What should we do about this, which seems to me among one of the biggest issues, that really face trust in the public and big tech in the public sector today.
Yeah, I could not agree more. I've silenced my phone here when I come on the panels, but here's where I usually would hold up a phone and just kind of note that they are ubiquitous. Almost, the cell phones that we have, and they're one of the very few things now that we have that travels with us wherever we go. And so, some of the most private data that we have now is also associated with that telecom instrument and where it goes, where it travels. And so this gets into geolocation issues and tracking and surveillance. The FCC, of course, has direct authority through our privacy protections under Section 222. And we have brought enforcement allegations related to this, where a couple of years ago, and something that I've spoken about, you had major telecom providers who were selling data and privacy and geolocation information to what are called aggregators that were then selling it, frankly, to anybody and everybody. And it was a very dangerous practice we saw in a lot of ways. And so, when you're talking about these issues, I think it is deeply important where the public is looking for us to vindicate their trust and making sure that these devices are safe, especially in the tech telecom sector. And so it is talking, and we need to finish looking through these jobs. Obviously, privacy is something that Congress is looking at as well, but I think we all need to lean into our scrutiny and lean into our authorities to make sure that we're keeping everyday Americans safe.
And if I can just say really quick, to put a finer point on it, I know I said big tech, but when we talk about cell phone location data, there's also big troves of data that we knew from the Snowden disclosures and even recent major newspaper stories that it's the telcos, that collect this data too. And I assume, especially given your remit in the FCC, if that applies as well.
Yes, again, like I said, this does get into some line drawings where, again, the location aggregators, the data aggregators, would be subject to other folks' authority, to the FTC or to the Department of Justice or to state attorney generals. And I've spoken with almost all of those folks as well. But when you're talking about the major telecom providers who are providing that telecom service, and that generates the data that then is sold downwind and downstream to other parts, and the dangerous practices of that is definitely us at the FCC. But again, taking a step back, I think the point holistically is that the issues of privacy are so complex. There is intersectional jurisdiction but it is really important that Americans be able to trust and know that they can use these services. Again, when you're talking about seniors who are also trying to figure out whether they can trust these devices, so much of this is important to let folks know that they are going to be protected. And if there are practices that are shady or result in safety breaches, again, we've seen examples where somebody who has a court order that they're supposed to stay away from somebody was able to geolocation track them by just paying $50. And they were able to track that phone and go look up somebody that they were barred by the court from finding. And I've previously served as a prosecutor where you're trying to protect people, and we just simply cannot have that.
Jack, can I jump in on that point?
Yeah, absolutely.
It's really important to think about this issue around privacy and recognize that we have an institutional problem in the US in that Congress is not able to function. In the normal world, Congress would operate in what's called normal order. They'd be holding hearings, they'd be understanding the problem, they'd be designing solutions. There is bipartisan support to address a national data privacy law. 50 states have data breach laws. Congress has been unable to act. What that has meant in practice is that the states and state attorneys general have had to pick up slack. You're seeing states pass data privacy laws, which economists would call a second best solution. I'd rather see a federal law with state AGs able to enforce it. Also, you're seeing agencies like the FCC and FTC acting in what I call, and I'll put the article in the chat, an entrepreneurial capacity. The FTC has built up an entire oversight regime over cybersecurity, data security, without Congress really asking them to specifically, but concluding that it was an appropriate use of their basically unfairness authority governing unfair trade practices and misleading consumers. That is filling a breach that needed to be filled. Similarly, NIST, the National Institute on Standards and Technology, has addressed data security and cybersecurity, filling this. And similarly, the FCC has stepped in with different approaches. This is all accommodating the fact that Congress has been unable to do this. In the first best world, we would see Congress leading on this issue.
If I could ask Commissioner Wilson to jump in.
Jack, can I jump in?
Yes,
absolutely. So I would echo both what General Weiser has said and what Commissioner Starks has said. Consumers need transparency about what is happening with their data. As Commissioner Starks mentioned, so much of our most personal data and information is being hoovered up, and consumers don't understand what's being collected, how it's being shared, used, monetized, sold to third parties. And so I think we need to get a handle on that and provide guardrails for businesses. Businesses need certainty and predictability, and the patchwork that is emerging among the states is in the end not, as General Weiser noted, the first best solution. And frankly, we have different jurisdictions around the world creating privacy, have a federal privacy law, doesn't even have a seat at the table in these discussions. I mentioned that the Federal Trade Commission and the Department of Justice have played a pivotal role in developing best practices for antitrust enforcement for decades, and they are a leader in those discussions with other jurisdictions. We cannot be a leader in the discussions about protecting consumer privacy and data security globally if we don't have federal privacy law and data breach legislation. And so I absolutely echo the calls of commissioners on both sides of the aisle, from the Federal Trade Commission going back years and years, begging Congress to pass federal privacy legislation. But in the interim, the FTC has used to the full extent that it can its authority to ban unfair and deceptive acts or practices. We have brought many cases, actually under Chairman Miras, we brought some of the seminal cases against Lilly and against Microsoft, and began building out this body of law about what we expect of companies in this economy when they are collecting the information of consumers. And I think when you think about it from a perspective, not just of the commercial data, but then how that gets used by governments, our civil liberties are imperiled at this point, given the vast troves of data that are collected commercially, but then are available to the government. And so I think free speech and free association and our Fourth Amendment rights are being eviscerated. And so it's not just a matter of commercial privacy and data security. It is now a matter of our civil liberties, and I would love to see Congress act this term.
Commissioner, when you said hoovering, this reminded me of when we covered the Snowden disclosures at the AP and how we talked to engineers at one firm when the feds would come in and gather the data. They called it hoovering, but not like the vacuum, but as in J. Edgar. So that was their little term of art around that certain company. I'm glad that we went down the privacy vein, because I had a question that we've talked about before, Commissioner Starks, in the past about racial justice, and I just wanted to get your thoughts on this. These racial justice demonstrations, Minneapolis and beyond, have really sort of brought into, I guess you would say, sharper focus that communities of color have toward their government and toward powerful interests. And just if you could maybe share sort of your privacy concerns that you see affecting low-income citizens, especially citizens of color.
Yeah, two things quickly come to mind. The first is, and it also kind of, I was jogged by Commissioner Wilson's points there. There was a recent inquiry that was from Senator Wyden and other folks on the Hill that was talking about bidstream data that was being used to profile, in particular, African Americans, and the data was siphoning off of and profiling folks based upon their attendance at Black Lives Matters rally and houses of worship. And I believe that some of those companies and those potential allegations have been commended to the FTC. And so we don't need to delve into those there, but it really showed that, again, more data is being deployed and profiled and monetized specifically in a race-based way based upon folks that were attending what is their First Amendment right to attend rallies, what is their constitutional right to attend houses of worship. And so that was troubling to me. I partnered with a couple of Congresswomen and also wrote a letter that highlighted that. I was deeply disturbed by that, but again, kind of reifies this notion of the need for data and protection. But within, more specifically, the FCC's lane, we have a low-income program called Lifeline, which is the only federal program as we sit here right now that provides connectivity, in particular smartphones, for low-income folks. But the fact of the matter is that there are several credible reports that these Lifeline phones being distributed to beneficiaries came pre-installed with Chinese malware. And that malware opened up backdoors to outside undetected monitoring and interference with the device. And in at least one case, it was impossible to remove that malware from the device. And so here's the point, is that we should, of course, not be asking our low-income folks that are getting a federal government benefit, because we know they need connectivity, and so we're making sure that they have that device, but they shouldn't have to trade off their privacy for it. And so, it is one of these issues where we have got to do better. We've got to partner with those that provide Lifeline phones, but make sure that there is the type of security that we're talking about. These are not trade-offs that low-income and vulnerable communities should have to make.
This reminds me, and maybe it's it's personally so during the pandemic. Some of us, a lot of us, are working with children at home. We're doing Zoom like we're doing right now. I think we're all tired of it, even with my Beltway tuxedo. But not everybody can do this. I mean, not everybody is fortunate to either be able to afford or, frankly, have the quite literally the bandwidth to do remote instruction, to do remote work if they're lucky enough to do it. I'd like to start with you, Commissioner Starks, on how policy is not sort of addressing this digital divide concern.
Well,
I'd like to get others' thoughts on this too, but I'd like to start with you.
Yes, and how much time do you have? But this is a fundamental issue of equity. And to the larger point that we're talking about today, trust that the government is going to respond. the fact of the matter is quite clearly, we've been talking about the digital divide for over 25 years now. The term was actually coined back in the early part of the Clinton administration. So we have been talking about who has and who has not in terms of connectivity for a really long time. But what we have also really seen now is that it has calcified, it has hardened. And so we do know that rural access is an issue. The fact of the matter is that if you are in a very low populated, low density place, making sure that the last mile of the internet gets out to you, that is a deeply important issue. And frankly, we've spent nearly $30 billion that are committed over the last couple of years, even since I've been a commissioner, to help that rural access issue. And so the good news is I think help is on the way. But in particular, there are over 20 million Americans, especially now more than ever during the pandemic, who simply cannot afford broadband, cannot afford that connectivity. I know when you're talking about folks that are trying to figure out whether they need to keep their lights on or get food or decide to keep their household lit up with connectivity, those are very hard choices. And folks are rightfully so going to decide to keep their family in their home, keep food on the table, keep lights on. And so I have talked about the need for us to have an affordable option for a really long time. The good news is here as well, Congress just in this last December package has a $3.2 billion low-income broadband connectivity program that we are working through right now as we speak. And so I'm very excited about this program. But the fact of the matter is that communities of color and low-income households are, even in 2021, by a wide margin, significantly less likely to have that home broadband connection that we need than their counterparts. And just to close, again, like I said, I can go on this forever. Connectivity is driving kind of the four big platforms that I think are that we see each day, and that is healthcare. Making sure that folks can keep themselves through telehealth and telemedicine. It's obviously driving our economy. Businesses that are able to have been able to quickly pivot to an online presence are obviously dominating. It is also helping on those personal connections. My family Zoom calls every Sunday to make sure that they can stay connected. This also helps with folks that are frankly being isolated here throughout the pandemic, something that we're all struggling with. And then the fourth big platform and plank that digital connectivity is dominating right now is, of course, something that you mentioned, Jack, and that is it's educating our kids. My 5-year-old is downstairs on Zoom school right now. And so we're seeing huge gaping disparities between those students that are able to connect and those that are, of course, getting further and further left behind.
We have about 22 minutes left, and I know Commissioner Stark, you have a very hard stop, and I know we're stopping here at then anyways. So I was curious if General Weiser or Commissioner Wilson, if you had any quick thoughts on that or wanted to move to questions. It's up to you.
I'll be really quick. We in Colorado are all in on this issue. To put a fine point on it, during the pandemic, lower socioeconomic, rural areas, inner city areas, often people of color, are those who are being hurt, disadvantaged, on top of prior disadvantages through an online learning gap.
Yeah.
The pains and trauma and impact of this pandemic that we're going to see to kids is going to be one of the things we're going to look back on and say, why didn't we do more sooner? So we in Colorado had a merger conditions with T-Mobile and Sprint for hotspots that we required to be used for those who face this online learning gap. We worked with our governor to have CARES Act funds support this, and we filed the petition with the FCC. Thanks to support from Commissioner Starks, is now being considered to enable E-rate funds, which is usually for schooling, to be used for online schooling when your school's at home, like Commissioner Starks's child. I wish we could have gotten that considered sooner, but it's been considered now. We need to be all hands on deck. The access to broadband is not a nice to have thing. It is an essential element of healthcare, of education, of economic opportunity, and we need to do all we can to enable access and to address the digital divide.
So I'd like to go ahead and get to questions. We have several in the chat, so feel free to drop them in there. The first one we do have is from a student, Kelsey Fayer, and I wanted to see if I think Amy, if you could. Oh, there she is. Hello.
Hi, thank you. And thank you all for taking the time to do this morning. This has been really exciting to hear this conversation. So I'm Kelsey Fayer, as Jack mentioned. I'm a 3L at Colorado and Zoom School of Law now. So my question is for all three of the panelists, or just one, depending on time. So how do we create effective consumer protection incentives while refraining from putting the work on the consumer? So for the example of federal data privacy legislation, how do we step away from frameworks that overwhelm consumers instead of protect them?
So that is a fantastic question, Kelsey, and it's one that the Federal Trade Commission has been considering and has also been essentially trying to inject into the dialogue. There are statistics out there about how long every product or service that they use for every website that they visit. It's, you know, tens of thousands of hours. It's just literally impossible for consumers to quote control where their data goes in a knowing way, and we lack the transparency to understand, given the inability to read through all of those privacy policies, how our information is being collected, used, shared, monetized, sold. And so one of the ideas that we've been advancing to help fix this is accountability. In other words, laws need to be passed that will make companies accountable and to encourage them to be responsible stewards of the consumer data that they collect. So you're absolutely right. It used to be a focus on notice and choice and consent and consumer control over data. And in the world that we live in today, there is absolutely no way that all of the onus can be placed on consumers. And so when we're thinking about the kind of law that we want to pass, first of all, we need to rectify the information asymmetry. We do want more information out there available for consumers so that to the extent they have the information, they can make informed decisions about which products and services to use or which websites to visit. And I think that the nutrition label that Apple has recently rolled out for its apps could be a first step in sort of the private sector innovation that may help transparency. But in the end, it is so difficult for consumers to read all of the privacy policies and then make informed decisions that accountability is an absolute imperative in federal privacy legislation.
So I'd like to go to our next student question. Bryla Andrade, if you could go ahead and just introduce yourself and ask your question.
Hi, I'm a 3L at Colorado. I actually interned for Commissioner Starks 2 summers ago.
Yes, you did.
Hey.
Hello.
So I wanted to ask you about, you know, we talked about Zoom and talked about people's access, and I'm very fortunate that I do have okay internet, but I am on satellite internet, and my data caps, you know, kind of back me into a corner every month, because at the end of the month, I really can't have video, do any streaming. And so I wanted to know what your thoughts were, both Phil as a state regulator and Commissioner Starks as a federal regulator. How do you solve the access of data caps and the pressure they put on people?
Well, you know, it is a good question. It is great to see you again. To hear that you're a 3L getting ready to fly the nest here gives me like millions of Americans everywhere. We are relying on memories on a lot of things, and I think you were probably my first cohort of summer interns, and so glad to hear that you are getting ready to move beyond law school, and obviously eager and excited to see what you can achieve. You know, it's a great question. This is one of the issues where we talk about making sure, you know, we think through what are folks, you know, obviously when you're talking about wireless and you're talking about satellite broadband, those are part of the service that you sign up for. This again pivots into what you're talking about, especially during the pandemic. You're talking about households who have two parents who are trying to work, one or two. The average household has 2 and some odd kids, kids that are trying to learn as well, in addition to video streaming. And this is one of the issues that I think the good news is data caps, just by the competition in the market, continue to go up and up and up. But we have continued to see the need for more and more data as more and more of our everyday activities are being driven online. And this is something that I have battled with, as I mentioned before, with Lifeline. Where folks have a limited number of minutes and a limited, 1,000 minutes and 4.5 gigs of data with their Lifeline phone. We're seeing that they're blowing through that because they do need to contact and try to find a job now more than ever. They do need to contact their medical service providers now more than ever. They do need to talk to family so that they can get the, get the connections and the mental health breaks that they know that they need. And so data caps are something that we're going to continue to see and evolve with, but totally understand your prospect there.
I want to pick up and leverage Commissioner Wilson's point and share Commissioner Stark's appreciation for Brylan, who's really a star and a great example, as is Kelsey, about what the Silicon Flatirons program is about and what Brad Bernthal mentioned about the students who we really put front and center. The idea that you've put your finger on is you are a sophisticated consumer. There are a lot of consumers who are not as sophisticated, who might not dig through different fine print. And what Commissioner Wilson said is it's very important to inform consumers in a fair, upfront way so they understand what they're getting. And one of the concerns that I have to my role is to address the issues where people are getting surprise bills, charges, or limits on the back end because they haven't been disclosed properly on the front end. And that's something that we look at not just in telecom, but in other areas. I'll give you a quick example. We had a company that was a lawn services company, signed people up, got their credit card, kept charging for an ongoing service that people didn't know they'd purchased. That's not okay. That's taking advantage of people who might not be scrutinizing their credit card bill or scrutinizing the fine print. We need to make sure consumers are treated fairly, and that's a good point that both you, Brylan, and Commissioner Wilson raised.
Jack, I saw a question just pop up from Paul Allen that I think would be really interesting to answer. May I take the liberty of addressing that question?
Sure.
So Paul asked a question for Mr. Weiser and Ms. Wilson. FTC Commissioners Slaughter and Chopra have said they want the FTC to conduct rulemakings to adopt new regulations to protect consumers and promote competition in the major tech platforms. Do you think the FTC should do this? Does the FTC have authority from Congress to do that today? So this is an issue that my colleagues have raised. Acting Chairwoman Slaughter and Commissioner Chopra have indicated that in the absence of congressional action on the federal privacy legislation front, it may be appropriate for the FTC to move forward. Now, for those of you in law school, you'll appreciate when I say the Administrative Procedure Act makes rulemaking somewhat smooth and seamless. The FTC actually has a higher burden on rulemaking if Congress has not specifically asked us to make a rule. It's called Magnus and Moss rulemaking. It takes longer. The hurdles are higher. But it is possible that the FTC could move forward with rulemaking on both privacy and data security in the absence of a congressional request. It will take longer. And for those of you who know me, if you spent 5 minutes talking to me, you will know that I oppose rulemaking. I oppose any attempt to engage in industrial engineering unless there is a market failure. But here I believe there is a market failure. There is such a significant asymmetry between what companies know about how data is collected and used and between what consumers know that we have a market failure. Consumers are not able to make informed choices about which products and services and apps and websites to use or visit or patronize. And so in the face of that market failure, and in the face of congressional inaction on the federal privacy legislation front, and as General Weiser noted, we're all asking for it, and Congress has failed to deliver it. I actually am beginning to consider the wisdom of launching a MAGMOS rulemaking on privacy and data security. I would hope that Congress will act, but if Congress doesn't act, maybe we do spend that time. It is a second best. It's not even a second best, it's a third best. But maybe that's what we need to do in order to bring certainty and predictability for businesses and transparency for consumers.
Jack, if I can follow.
Sure, go ahead. Sure, and then I have a couple of questions I'd like to get to.
I'll be quick. Commissioner Wilson, I wish I could give you a virtual hug because both the substance of what you just said is so important. And for people here, I echo these remarks. This is not a first best solution. It may not be a second best solution, but we're not in the first best world. We may not be the second best world. I think your reluctance for this is appropriate, as is your openness to it. And I just want to underscore, at a time of a lot of governmental dysfunction, a lot of political polarization, what you're seeing from Commissioner Wilson is what the FTC was created to do. And I know all 4 commissioners who are outstanding public servants, who engage with rigor in their work and who are committed to collaborative problem solving. And I just commend that spirit. I know Commissioner Starks brings that spirit at the FCC. I don't know all your colleagues as well as I know the FTC colleagues. And I'm with you to work on that issue. It's important. And unfortunately, we've been waiting for Congress for a long time to lead in this area. We've given them plenty of opportunity. I do think these sorts of rules are an appropriate step, and I look forward to working with you on that.
And as a journalist, I get my mileage out of the APA with the federal FOIA, but that's a topic for another day when it works. So one of the questions here from Callie Schroeder, this is for Commissioner Starks, but other panelists can jump in. So when attempting to be neutral in rulemaking and enforcement, et cetera, how do we adjust for circumstances where the rules are purportedly neutral, but the effects and outcomes are decidedly not? So for example, Callie says, when all telcos have to hit baseline infrastructure requirements, but established and larger companies are able to edge others out because they essentially given a head start.
Let me unmute here. It's a great question. The first thing that flashes to my mind is that we have a 20 billion rural digital opportunity fund that is paying for broadband to get built out into, as I mentioned before, a lot of those rural areas where otherwise the market is not going, there's not a market case for somebody to get out into that rural, low densely populated area. And one of the things that I have focused on is that when a provider wins the contract that we the FCC pay them to build out to, they actually need to perform, because you do have a lot of folks who say, well, my bid is based upon A, B, C, D, E, F, G. But the fact of the matter is that when you submit that bid, we are relying for you to get out to that community. And so to the question, there are very neutral platforms where we say, hey, you have signed up to be a rural digital opportunity fund provider, and we expect you to perform. And so there really are neutral rules, and I think that's actually a very fair way to do it. If somebody comes to us and says, I want to take that bid, and we do our due diligence and they're able to perform, then we need to hold them accountable, especially on something like the digital divide. But I don't really see that there's a problem between some of the largest companies and some of the smallest companies. You'd actually would be surprised if you look at who wins these bids for rural digital areas. It's not all the gargantuan folks. Frankly, the gargantuan big ones are the ones who are not out into that area. And so it's a lot of local telcos, frankly, who are the ones who actually decide to build out. And so, I think neutral rules that are evenly enforced is in fact the best practice there.
So this next question is for you, General Weiser. Ron Mayer asked, it is on record that certain financial powerhouses dictating elections have a belief that the general idea that disordered government is the best form of government. To your point on Congress, really your all point on Congress is not functioning. How do you fight forces like these that are specifically designed, in Iran's view, to create disorderly government, or has that train left the station?
Well, I think that the reasons behind a dysfunctional Congress are complex and go decades in the making. One of the reasons is cultural and relational. It used to be 20 years ago that Ted Kennedy and Orrin Hatch had a friendship, had an ability to work together on things that they agreed and could disagree civilly. The level of polarization and demonization have really been a troubling trend. And again, the contrast to what you see from the FTC commissioners is, to me, heartwarming and valuable. And so I think part of what we have to do is work on the cultural relationship level, empathy, listening, collaborative problem solving. Another point is institutional, and is because of the way a lot of elections are decided in primaries, not in general elections. And that drives sometimes people away from collaborative problem solving, because in some primaries, it is a sin to be working across party lines. I mean, Ted Kennedy did so, not worrying about getting primaried, same with Orrin Hatch, but Orrin Hatch's colleague, I think it was Senator Bennett, was primary because he was willing to work with Democrats on solutions. So that dynamic, I think, is a big issue. And then, yes, there are different economic interests who might have a stake in gridlock, but I actually probably put that third on the list I just offered, because there are economic interests who might have a stake in congressional action, and they can't get action either, because Congress has been so disabled from functioning what I called regular order. The Telecommunications Act of 1996 and the Cable Act of 1984 followed sustained hearings and collaborative work to both get passed on a strong bipartisan basis. They weren't perfect pieces of legislation. They reflected a lot of compromise, a lot of work. The challenge right now is, can Congress do that work? And if not, we're seeing other institutions like the FTC, what Commissioner Wilson talked about, like states and state attorneys general, having to fill that breach.
So that leads me to, I think we have time for one more question here. Someone asked, this is specifically for Commissioner Wilson. Given the fact that there is no transparency, this person asked, for consumers on data privacy, how soon will the FTC be bringing Section 5 unfairness cases against tech companies? They say there's no need to wait for a federal privacy law. The authority is there.
So the Federal Trade Commission has actually been bringing cases in the privacy and data security space for a couple of decades now. As data security cases was Microsoft that was brought under Chairman Miras, and then a case against Lilly. There, Lilly was selling Prozac, and it created essentially a support group for people who took Prozac, and inadvertently, in the process of collecting emails to send out news, sent an email to all the members that was not BCC'd. So in other words, it disclosed the names and email addresses of everyone taking Prozac, including lots of folks in government. And this was during a period when I think there was much more of a stigma about mental illness and depression and anxiety. And so we used Section 5 in 2001, 2002 to go after that practice. And since then, we have brought hundreds of cases in the privacy and data security arena, including against Google, against Facebook, against Twitter. There are a number of companies that are under order with us, and that is, it's increasingly common. And then in perhaps the most important case of my tenure, we launched an order violation investigation against Facebook, who was under order with the Federal Trade Commission for privacy issues and violated or breached the terms of its order. And so about a year and a half ago now, we actually sued them for violating the terms of their order, and then settled that suit for $5 billion in civil penalties. That's not 5 million with an M, it's 5 billion with a B, which is the largest civil penalty in the United States to date, save for Deepwater Horizon, where, you know, obviously livelihoods were destroyed, and the havoc wreaked on the environment was monumental. In addition to that civil penalty, we also obtained a lot of different types of injunctive relief that required, for example, Mark Zuckerberg personally to certify on a quarterly and a yearly basis that Facebook is complying with the terms of that order. There's now a privacy committee on the Facebook board that is responsible for ensuring compliance with and attention to the FTC order and consumer privacy and data security issues. And I think that order is a fantastic model of what can be accomplished in the absence of federal privacy legislation, but it, you know, we pushed our authority to the limit. We can't change the business model, but back to the original question, we've done studies, we've done enforcement actions, and we are doing everything we can with the limited authority that we have now.
Well, I think that wraps it up. I think this has been a very thoughtful discussion. Commissioner Starks has to go, so I'll turn it over to Amy very quickly.
Thank you so much, Jack, to Commissioner Wilson, to Commissioner Starks, AG Weiser. I really appreciate you coming out. We are going to have the video up in about a week or so, and I'm so excited